Welcome back and thank you for joining us. This PowerPoint presentation and the accompanying narration was created for East Texas Baptist University for use in the course Criminal Justice 1311 Fundamentals of Criminal Law, and I'm Dr. Eric Hillman. The textbook that we used in this course is called Criminal Law, 12th edition by Joel Samaha. The student's viewing of this presentation is designed to supplement the reading of the text and not simply to replace it. Chapter 7 is entitled Parties to Crime, Accomplice and Accessories, and Vicarious Liability. Chapter 7 has been divided into shorter segments for easier online viewing, and this is Chapter 7A, the first segment. This picture that you see obviously is set up. It's not a real murder. But let's say, for example, if this couple decides to kill their child for insurance purposes. Maybe they have a big insurance policy on the child. So what is the dad doing? He's holding the child's hand. Is it illegal to hold your child's hand? Of course not. What's the mother doing? Well, she's about to stab the child with a knife. So the mother is the one that actually does the killing, not the father. Is the father just as guilty of murder as the mother when all he did was hold the child's hand? That's the type of issues that we will talk about in this chapter. Can you be liable for another's crime? The term vicarious liability says that your relationship makes you liable for someone else's crime. Relationship is underlined, so that's the key. Vicarious liability can sometimes be found in employer-employee relationships, where the employer can be vicariously liable for the employee's crime. And sometimes in parent-child relationships, some states have vicarious liability laws that allow the parent to be liable for the crime of the child. Complicity, on the other hand, makes your participation makes you liable for someone else's crime. So we have a different word underlined. Complicity means you have to participate, whereas vicarious liability makes your relationship makes you liable. So, for instance, what if you are a getaway driver at the bank? We're talking about the picture in the upper right. If you're a getaway driver, you are an accomplice. An accomplice participates before and or during the commission of the crime. Since the getaway driver, although he never goes into the bank, since he's participating during the commission of the crime, he is an accomplice. And he then becomes liable for the robbing of the bank just as much as the people who went inside with ski masks and guns. Accessories, on the other hand, participate after the crimes are committed. So accomplices participate before and during, accessories after. If your friend robs the bank and you knew nothing about it, but then he comes to your house and says, "Quick, let me in. I need to hide. I think the police might have spotted me. Here's my mask and my gun. Go throw these in the dumpster." And you agree to hide him, and you agree to throw the mask and the gun in the dumpster. Even though you did not participate before or during, you did participate after, and you would be considered an accessory to a crime. So, again, accomplice, if you participate before or during the crime, you will actually be charged and prosecuted for the crime itself. So the getaway driver will actually be charged with bank robbery, even though he never touched a gun and never went in the bank. So if you are an accomplice to murder, you're actually charged with murder, even if you never pulled the trigger. An accessory, again, is someone who participates after the crime. An accessory is not charged with the crime, the accessory is charged for a separate lesser offense. So, for instance, in this top picture, two men with masks are robbing a bank. They are guilty of bank robbery, and the accomplice, who is the one in the getaway car outside, is also charged with bank robbery. But when these two guys get home, and one of them says to his girlfriend, "Here, take this ski mask and don't throw it away here. The police might look through our trash. Go drive a few blocks down to the park and throw away the ski mask in the park." And his girlfriend does. She's not an accomplice because she didn't participate before or during, but she is an accessory. She participated afterwards. And so she'll be charged with a lesser offense of accessory to a crime. Often, that's a misdemeanor, and we'll find later that in Texas, even being an accessory is, in many cases, a felony. But they're usually charged with obstruction of justice or destroying or hiding evidence. So here, when all three are caught, the two men who entered the bank will be charged with bank robbery. The man in the getaway car will be charged with bank robbery because the getaway car is an accomplice. But his girlfriend is an accessory. She destroyed or hid evidence after the crime. And in most states, she would be charged with a lesser crime, a misdemeanor crime of being an accessory. Now, we've known since the beginning of this semester that every crime must have an actus reus, a criminal act. What about an accomplice? Well, an accomplice also has to have an actus reus. They have to somehow act in aid of the offense. And so the actus reus for the getaway driver is aiding the bank robbery by driving the getaway car. What if some friends want to break in the house? And you say, "No, I won't break in the house with you, but I'll go behind the house and cut the wires to the burglar alarm while you break in." Well, the person cutting the wires to the burglar alarm aided the offense, acted in aid of the offense, and so he is an accomplice, and he, even though he never goes in the house, will still be charged as a burglar. The words you most often see in the statutes for accomplice, actus reus, are aided, assisted, counseled, procured, hired, induced. So if you provide guns to someone who's going to commit a robbery, or supplies, rope and duct tape, someone's going to commit a kidnapping and a rape, you drive a getaway car, you fool the victim by sending him to the criminal so that he can be ambushed. Or someone's going to warn the victim, "Watch out, this is a trap," and you prevent that warning from getting to the victim, you would be an accomplice, and you can be charged with the crime itself, even though you didn't actually commit the crime, because you aided the offense. What about words alone? Can they be actus reus? Yes, they can. So, if these four gang members beat somebody up and rob them, then certainly all four will be charged with assault and robbery. But what if only one gang member beats somebody up and the other three stand around and say, "Yeah, you can do it, you can do it, show him who's boss, beat him up, beat him up"? Well, in that particular case, all four could be charged, because even though only one did the beating up, the other three encouraged the crime, and so those words can be an accomplice, actus reus. What if you're just standing around? Well, mere presence at the crime scene is not the same as actus reus. So if you're standing around with a group of young folks at a school and one of them sells drugs to a second one, well, just the fact that you happen to be there too doesn't make you guilty of selling drugs. So just being present doesn't make you guilty. What if one of these students sells illegal drugs to another, and then you see the school police, ISD police, and so everyone takes off running? Well, even that's not enough for actus reus. So simply being present doesn't make you guilty, and being present and running away doesn't make you guilty. There is an exception. If the defendant has a duty to act, then presence alone, mere presence, can satisfy the actus reus requirement based on the omission rule. Remember, we talked about the failure to act can be an act, but only if you have a duty. Now, obviously, the woman in this picture is a good mother, but if, for instance, her boyfriend sexually abused the child, and I'm not saying it happened in this picture, I'm just making up a story, but if her boyfriend sexually abused the child and she was present and did nothing to prevent it, then yes, she does have a duty to act, and her actus reus can be satisfied by her mere presence. In a true case, Mrs. Walden had a 1-year-old son. She had a boyfriend who beat her son until he was bloody. He did it several times. Each time, Miss Walden did nothing to stop him. So she is charged as being an accomplice to the assault. So obviously here the boyfriend is charged with assaulting the child, and Mrs. Walden or Miss Walden is charged as an accomplice. And she says, I didn't hit the child. And the court said, well, your actus reus, your criminal act, is an omission, a failure to act. Why? Because you have a duty. You are the child's mother. Since she had a duty to stop him, her failure to act becomes her accomplice actus reus. All right, Bailey and another man were playing craps. A man who looked rich walked by, and Bailey's craps partner pulled a gun and robbed this man at gunpoint. Once he robbed the man, he fled. Well, Bailey saw what was happening. He fled too, but he was caught. So they caught Bailey, and he's charged with robbery also. And he says, wait a minute, I didn't rob, I didn't aid, I didn't abet, I didn't assist, all I did was run away. And the court said, mere presence isn't enough, and fleeing from the crime scene is not enough. So in this case, Mr. Bailey is found not guilty. Innocent people can flee for fear of being accused or not wanting to testify as a witness. Now, you have a moral duty to assist the victim, but apparently in this case, because it's a stranger, you have no legal duty to assist. So just being there, as long as he didn't encourage it or assist in the robbery, he's not guilty of it. And merely running away is also not enough. Mr. Bailey may be a bad person, but he's not guilty of robbery. Very interesting case coming out of Minnesota, State versus Olvenen. Dave allowed his mother to move in. By the way, that's a mistake. Against his wife's wishes. So there has traditionally and for generations, probably centuries and millennia, been conflict between mothers and the new wife, between the wife and the mother-in-law. Well, needless to say, the wife did not get along with her husband's mother. Conflict, two women living in the same house. So his wife said, get your mother out of here. And his wife threatened to take the kids and move out. So now Dave's looking at either telling his mother to move out, or his wife's going to leave. He's going to lose his wife and his kids. So he's in a difficult situation. He's upset about it. He tells his mother, I ought to kill my wife. His mother said, yeah, that would probably be the best thing to do. Now, this is a court case against the mother. Dave is going to be found guilty of murder. That's not the issue here. The issue is, what is the mother guilty of? So we're at the mother's trial, and Dave testifies, yeah, I told her I was going to kill my wife, but I was just frustrated. I didn't think that she believed I would really do it. One night, Dave and his wife, after a pretty difficult day, Dave loses his temper and strangles his wife and kills her. Then, realizing what he's done, he goes to the other bedroom and wakes up his mother and said, "I killed my wife." Dave said, "Mom, sit on the couch here in the living room. Now, if the kids wake up, you get them a drink of water, you get them whatever they need, but do not let them come to the bathroom, because I'm going to carry my dead wife to the bathtub and cut her up." Obviously, he's got to dispose of the body, and you don't just walk out of your house with a dead woman over your shoulder. So he wants to cut her up and take her out in small packages that doesn't bring attention to himself. So his mother does exactly that. She sits on the couch, ready to intercept the children. Dave cuts up his wife. He finds a place to bury the body, cleans up the whole mess, and then reports his wife missing to the police. Well, of course, his wife's family is not so easily convinced. He's eventually caught, and he confesses to the police that he killed her, and Dave is charged with murder. Dave's mother then was also charged with murder as an accomplice. So, what's happened here? Dave kills his wife. He's clearly guilty of murder. What did the mother do? Did she aid before or during the offense? Well, actually, she was asleep. So pretty difficult to say she's an accomplice. What did she encourage it? Well, that's what the court is trying to do. That's what the district attorney, is trying to do. He's trying to say she's guilty. Dave's mother is guilty as an accomplice because Dave's mother encouraged him. Well, that's why Dave's testifying. Yeah, I told my mother I was going to kill my wife, but I didn't think she'd believe me. So Dave, he knows he's going to prison. So he's trying to save his mother from going to prison. So he says, no, she wouldn't have believed me. But his mother's charged as an accomplice. So the state has to prove that she participated before or during. Now, did she participate afterwards? Of course. She was there to help hide the evidence of her son cutting up the wife's body. She sat on the couch to intercept any kids that might wake up. So Dave is charged as an accomplice. I'm sorry, Dave's mother is charged as an accomplice, but really, what is she? She's an accessory. She helped after the fact. So this goes to the Minnesota Supreme Court, and the Minnesota Supreme Court says, during the murder, mother was asleep. She didn't know this was happening, so she didn't assist during the murder. Did she assist before the murder by giving encouragement? Well, they were just two angry people talking about someone they both disliked. Accomplice liability, which is what mom is charged with, requires more than just inaction. Yes, she had a moral duty to warn her daughter-in-law, but she had no legal duty to warn her daughter-in-law. And so in this case, the conviction was reversed. The Minnesota Supreme Court says, no, mom is not guilty of being an accomplice. She didn't assist before or during. She did assist afterwards, so she is an accessory, but the state of Minnesota did not charge her with being an accessory. They charged her with it being an accomplice, so the Minnesota Supreme Court overturns that. The accomplice mens rea. Now, we already talked about actus reus, the criminal act. What about the criminal mind? Let's look at the word intentional. I agree to lend my gun to Ureen to rob a store if she agrees to give me half the money. So Ureen tells me she wants to rob a store, but she doesn't have a gun. Well, I've got a gun, but I don't want to rob a store, so I give my gun to Ureen. She robs the store. She comes back, gives me half the money. Am I an accomplice? Well, in this case, yes, because I aided before I gave her a gun and during. Well, I don't know if I aided during or not based on that fact scenario, but certainly before, and so I am an accomplice. Even though I never went to the store, I can be charged with robbery as an accomplice. What about the next mens rea, knowingly? I know Vanessa's selling drugs and her cell phone quits working and she's going to lose a lot of drug sales, so she says, Dr. Hillman, I'll give you $500 for that cell phone. I can't lose all these drug sales, so I sell her my cell phone. I don't have anything to do with the drug sales, nothing at all. But I know she's going to use that cell phone to sell drugs. So am I guilty of being an accomplice? Now, if I intend, I clearly am, but what if I just know? I have knowledge of what she's going to do, but I'm not participating, and I'm not encouraging or anything. Well, the courts disagree that knowledge is enough. I mean, probably many of you in your life have been aware that certain people in your neighborhood or your school use drugs or maybe even sell drugs. And your mere knowledge that they're going to do it is not going to be enough to make you guilty in most cases. But courts disagree on that. All right, so let's look at a case with an armed robbery and attempted murder. The People versus Popular. Some states entitle their criminal cases State versus Smith. Some, they name the state, Texas versus Smith. Other states say the People. So Popular and several friends drive around in a car together at nighttime. They have a shotgun in the car, and everyone knows they have a shotgun in the car. They see a bowling alley that's closed. This is the middle of the night. The bowling alley is closed already, and they say, hey, let's break in and steal whatever we can get. So the friends broke into the bowling alley while Popular stayed outside as a lookout, going to make sure no one interferes with the robbery. He never went inside, but as it turns out, the manager was still there. So one of the friends took the shotgun and shot and wounded the manager. So the people inside who were burglarizing the bowling alley were clearly guilty of burglary and in this case attempted murder. But what about Popular outside? Did he assist before or during? Yes, he assisted certainly during. He is charged with burglary and attempted murder, being an accomplice to burglary and an accomplice to attempted murder. So first of all, let's look at the burglary charge. Did he assist before or during the burglary? Yes, he did. So he is an accomplice to burglary. What about did he assist before or during attempted murder? Well, the court says yes, he is an accomplice to burglary, but they have to discuss the attempted murder charge to decide whether he's an accomplice to that. And the court goes on to say, Popular, even though he was outside, he knew his friends were committing a burglary, and he knew that they went in with a shotgun. So, when they went in with a shotgun, he knew that committing a burglary with a shotgun, taking it with you means you might use the shotgun. So, and the court uses this language, which is commonly used by other courts, the use of the gun was within the scope of a common unlawful enterprise. So the common unlawful enterprise is the burglary, and clearly Popular's accomplice to burglary. Now he's going to say, I didn't know that they were going to shoot the manager, so I shouldn't be an accomplice to attempted murder. But the court says you knew they had a gun, you knew they were committing a burglary with the gun, therefore the use of that shotgun was within the scope of what they were doing, their burglary. And therefore, knowing they went in with the shotgun and still acting as a lookout means that you are responsible as an accomplice for whatever acts they commit, including shooting the manager. So he's also guilty of being an accomplice to attempted murder. Let's look at a case out of Arkansas. two men, Lewis and Wren, were both drunk. They are in Lewis's car. Lewis knows he's drunk, so he lets Wren drive. The problem is Wren's drunk, true, but Lewis is in the passenger seat. Wren, who's drunk, crashed the car and killed Mrs. Pounds. So you've got a DWI fatality. They call that intoxication manslaughter in Texas. So certainly Wren, because he is DWI, crashed a car and killed a lady, is guilty of, well, this is an Arkansas case, but in Texas they would say intoxication manslaughter. But what about Lewis? He was just in the passenger seat. Should he be responsible for Wren driving drunk? Lewis is charged as an accomplice, so Wren is clearly guilty of intoxication manslaughter, but what about Lewis? Is he an accomplice? He says, hey, mere presence. I shouldn't be guilty just because I was there in the car with him. So that shouldn't be enough, and this goes to the Arkansas court. Lewis was convicted as an accomplice to criminal homicide. That's what they called it in Arkansas, and he appealed. No, I'm not an accomplice. I didn't assist before or during the crime. I didn't encourage the crime. My mere presence isn't enough. But the Arkansas Supreme Court says, well, Mr. Lewis, you knowingly allowed a DWI driver to drive your vehicle. You sat next to him. You didn't protest the reckless way he was driving. You didn't stop him from driving. You gave him permission to drive, even though he was clearly drunk. You're just as guilty of homicide as the driver. So to be an accomplice, he's got to have some mens rea and some actus reus. Well, he certainly didn't intend for Mrs. Pounds to die, but what was his mens rea? His mens rea was his actus reus, his criminal act was giving the keys to Wren and saying, you can drive my car, even though he knew Wren had been drinking. That was his actus reus. What about his mens rea? Well, in this case, it looks like even though he didn't intend for Mrs. Pounds to die, he did intend for Wren to drive drunk, and that's going to be enough for this criminal homicide in Arkansas. So Lewis, by giving the keys to his drunk friend and letting him drive, becomes guilty as an accomplice. And that's the end of Chapter 7A. Once you finish viewing this presentation and taking notes, I encourage you to continue on to Chapter 7B. Thanks and have a great day.